Hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within ample of the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to this sitting of the Appeals Court. It is my great pleasure and privilege today to be sitting with Justices Milkey and D'Angelo, and I am Justice Wolahojan. I see that we have many familiar faces in the room today, so I won't go through in great detail the ground rules, but I'll mention a few of them. Each side receives 15 minutes to argue. We have no rebuttal, so you don't reserve time for rebuttal. The yellow light goes off about a minute and a half before your time expires, so that's to give you a chance to try to conclude your argument in a graceful way along the lines that you'd like. When the red light goes off, your time is up, unless we have additional questions for you. You may structure your argument any way you wish. It is entirely up to you. However, you don't need to feel that you need to educate us on the background of your case. We have read the briefs. We've read large, if not all, portions of the record, so you can just dive into the legal issues. But again, you may structure your argument any way you wish. If your case is fully or partially impounded, I'll try to make sure I remember to note that when we call the case, but I'd also ask that counsel keep that in mind and not refer to the impounded information in open court. Usually that's a name or the names, and just let's all try to be aware of that. As I said, I will try to remind people before we get started. With that, I'm going to call the first case, which is 2023 P0173, Commonwealth versus Jermaine Warner. And is it Attorney Renaud?
Yes. Thank you. May it please the Court, Suzanne Renaud for Jermaine Warner. Your Honors, with your permission, I'd like to start, and it sounds like I can, start with the second argument in this case, because the issue at the heart of the second argument sort of permeates everything here, and that is...
I'm just going to ask you, Attorney Jermaine, would you please, Renaud, sorry, would you please speak up?
I'm sorry.
Or move the microphone.
The issue at the heart of this case really has to do with the probable cause of the location of the drugs. And as Escalera says, we need to have particularized information before we can enter into a home. And that is, in this case, that there's going to be some kind of stash of, other drugs that will be there, not just the one-off handoff that would have been made. Commonwealth versus Pena says the same thing. So, one of the things that you might ask is, can a drug sale itself be enough? And that might be the case if there is some indication from the officer's training and experience that the location of the drug sale is also going to be the place where the stash is. And so that could be the residence. And that's that is what is suggested in this search warrant, that a residence is going to be the place where the drug dealer who's selling is going to be keeping these things. So there is a connection, or otherwise there might be some kind of connection to the residence to the sale. And I think that is, again, what happened in Escalera, where the sales happened immediately, or there was some other part of the tip that kind of corroborated that.
Right. I don't remember. I mean, I was on the panel of Escalera here. I don't remember that the sales occurred inside the residence in Escalera. Am I correct?
They did not.
Okay.
They did not.
Here we have actually two sales that occur within at least according to the affidavit, occurred within a particular unit in a multi-unit residence.
That is correct. They're happening within a unit, so it is.
So do we have any case where we've said if the affidavit says an actual drugs transaction took place, or more than one, took place in a particular unit, that was not enough to establish probable cause to search that unit?
To my knowledge, there is nothing that is on point directly with this proposition. I think what I am trying to say here in my long-winded introduction is that what is happening in this unit, even if you accept that it's apartment 2L, is that that is nothing more than a convenient location until you establish that it is, in fact, Mr. Warner's residence. And so Escalera kind of stands for that proposition that, yes, they went to a different building and the drugs presumably lived or were stashed in a different location. And so,
does it have to be his residence, or could it be he lives somewhere else, but he uses that place in order to conduct drug sales?
Well, that is
a person.
Yes, Your Honor, and I think that that is exactly what the issue is here, which is, of course, it could be a different location than his residence, but then you need to have some kind of particularized information in this affidavit that says that why we think that apartment 2L is going to continue to have drugs in it. So yes, he could be using this as a stash house, but then you need to have some kind of information saying, well, he always sells out of apartment 2L. This is the place where he keeps his stash. There are certainly language and ways that you can go about that.
So two controlled buys from one location, I won't call it the residence. Let's use apartment 2L, where the police watch the CI, watch him go into the building, search that he has no drugs, no money, etc. He goes into apartment 2L, and he comes out with drugs. Well, that's not enough?
Well, Your Honor, there is a reason why I'm starting with the second argument here. I would say on that point, in this case, the location where the drug sales are going to take place are a non-obvious point, because the CI did not say in advance that these always happened in 2L. Even when he made the phone call to Mr. Warner, he didn't get told to go to apartment 2L until after he left the police. And so when you are dealing with that, all we know at the moment that those sales are taking place is that they, from what the CI said, is that they took place in apartment 2L. He didn't say, I saw a giant box with Mr. Warner. He didn't say I saw a bed. He didn't say I saw a letter.
Back to my question. A controlled buy in apartment 2L, two controlled buys, that standing alone isn't enough to establish probable cause to search apartment 2L?
Not if the only thing the controlled buy is, if the controlled buy does not establish a non-obvious piece of information. And in other cases, the place where the person lived was an obvious piece of information. And in this case, it's not.
May I ask you a question? I'm looking at page, the second page of the affidavit. Do you want to pull that out?
Which paragraph?
It's actually the one that's paragraph 3 under the title Investigative Overview.
Yes.
I'm just going to note something because you may want to deal with this in the future, but there's a Social Security number referred to in that paragraph that probably should be redacted, and you may want to.
Thank you, Your Honor. I don't think I noticed that.
Okay. So that's not what I was interrupting this entire argument.
No, I appreciate that. I
just noticed it myself. But the second sentence says, the target of this affidavit is Jermaine Warner, date of birth X, a black male who conducts his crack cocaine distribution business out of his residence at 42 Lyon, apartment 2L, Boston, Massachusetts, 02122. It says his residence. So why isn't that enough?
Because that's the investigative overview, and that's based on everything that follows. When this officer is saying that this is his residence, and that is, again, I'm 7 minutes in and I still haven't addressed what the issue is, especially when we get to prong 2, is how do we know this is his residence? Because this is not a case where, again, the CI had established facts to show that this might be a residence. This is not a case where the officers went and even talked to the landlord or looked at the door to see if there was a buzzer. They did nothing other than to cite to this 2018 search warrant to say that this is his residence. And so there is nothing here to assert or to assume that there is a residence. But even if on the face of this you believe that this is its residence because there was nothing telling you that it wasn't, this is where we get into part 2, which is
there's paragraph 8 that says he lives at 42 Lyon Street in Boston.
It doesn't say how they knew that. And if the fact that
why is that necessary? It does say that he knows that because he's been buying drugs from him in the past.
It says he has been buying drugs in and around the area of 42 Lion Street, and they've seen him around that area. So can you presume that he lives in that building?
It says in paragraph 8.
Your Honor, I think that what's happening here is that the officers are using language that's not exact, and how does he know he lives there?
But does it matter? I'd like to go back to my first question. Why does it matter if he's using that location? Why does it matter if he also lives at that location?
Because when this officer later on in his affidavit says that residences are the place where there is a stash, then you need to know that, because, and then adding to this, what if he lives in apartment 1L? What if the magistrate knew that apartment 1L was in this mix? So now you have information that less than a year before he lives in 1L.
Could you remind me, did the police see the CI go into 2L, or are they just relying on his saying that the buys were in 2L?
They're just relying on him saying that. What the way they described this, the controlled buys, is that the CI knew that he normally sold around 42 Lion Street. CI got a call to tell him to go to 42 Lion Street. They watched him go to the building. And then they said the CI came out and reported that he went into apartment 2L. There is no information here at all to assume that they saw him go into apartment 2L.
What do we know on this record about your client's ties to 1L, other than the fact that there was a search warrant of 1L?
Well, in 1L, first of all, that means the Boston police believe that's where he lived. That's what they said. The other thing is that they found some prescription medication at apartment 1L when they executed the search warrant in 2018. And so that, it's less than a year later. And what is happening here is, even if you're not 100% certain he lived at 1L at that time, or he still lives there now, what happens is, when you're dealing with probable cause, it's obviously based on probability, and it's based on inferences, and it's based on, particularized information. And if you are trying to say
I'm sorry, but I'm having a hard time understanding why the information about 1L, first of all, it's not inconsistent with the fact that an allegation that he's selling drugs out of 2L. It's not inconsistent. And I'm wondering why it doesn't actually buttress that allegation.
it is inconsistent in terms of where the stash is going to be located.
But no, how do you get there? I don't see that.
If he has an association with apartment 2L, Your Honor, that's where he sells. It's not really his residence, it's just where he sells. That means that he keeps his stash elsewhere. And
or maybe,
why? Why can't the drugs be in 2L and him live downstairs in 1L, making it a stash house or stash apartment?
Well, the problem with that, Your Honor, is that you need to have more information in the search warrant, because what happened here is that even the officer in his own training and experience said people keep their stash at a residence. So if the CI had come back with a detailed description, which he didn't do in this case, and there are other cases where this has happened, where he says
a detailed description of 2L?
Of saying, oh, I saw him pull a box out and the box had drugs in it. At least some kind of detailed information where you could make a presumption that he kept the drugs in apartment 2L. But he didn't do that. And whereas when you start adding 1L into the mix and you take the officer's own indication that stashes are often kept in residences, how do you reconcile those two things? Because now you have one.
Well, this is a residential building. Both of those apartments are residential units. So I don't guess I understand what exactly you're...
The point is, Your Honor, is that you need more information on either one of those points to say that this is, you have two equally possible.
So are you,
propositions
to me
at this
it sounds
point.
as though you're arguing that they should have, based on this information, obtained a warrant that permitted them to search both 1L and 2L. But that doesn't seem to me correct, because there's almost no information about 1L except the previous year he lived there.
But, Your Honor, I think that's exactly what the problem is that there isn't enough information on either one of them at this point. What would have happened, or what should have happened, is that the magistrate should have sent this back to get more information, because you based on the limited amount of information that they had before them.
Missing what additional information? So would 3 more buys in 2L have established, with nothing else, no description, but the CI says, I went to 2L, I got drugs from him 3 more times. Doesn't that establish that he's selling drugs out of 2L? And doesn't that give probable cause to search 2L, regardless of where he lives? He could live on the other side of Boston, for all we know. He's selling out of 2L. Why isn't that probable cause?
Well, again, the case law basically says that you have to at least have something that shows that he's showing up there very, very quickly. And that might, when somebody makes a call, immediately he says, oh, I have the access to these drugs. There is a case that says that. There are other cases where it says that one of the CIs saw that there was a stash. Otherwise, it's just a convenient location. He could be selling this on a stoop in front of a building, and it's the equivalent of selling on a stoop, just because it happens to be indoors in somebody's residence. So at minimum, there needed to be more investigation.
Counsel, I had thought your point in part was that the affidavit did not sufficiently establish that the controlled buys were in 2L, because the reliability of the informant has not been adequately established, and the police did not corroborate that he went into 2L.
That is certainly my first argument, Your Honor, because at this point, as I said in my reply brief, and I know I'm running out of time, there is, the word location has been used by this court and the SJC, even if you're not parsing things too hyper technically. That word location has been significant in the determination of what kind of information the past history of the CI has provided. And then when you add to that here this non-obvious detail of where the sales are taking place that is not corroborated in any way by the police officers. Mere fact that there were drugs that are being bought, that might be sufficient if you were just had a search warrant for Mr. Warner. But that's not the search warrant. The search warrant is to go into a home, somebody's home, to go and search it. And so that would be the basis of the first argument. I see I'm out of time. If there are no more questions, I rest on my brief. Thank you.
Thank you very much. And thank you for your able argument. Mr. Wolf.
Good morning. May it please the court, Danny Wolf, 303 for the Commonwealth. I am supervised today by Assistant District Attorney Darcy Jordan. I'm also joined today by the motion Assistant District Attorney on the case, that would be Alex Rahimi. The Commonwealth is requesting that this court affirm the lower court's decision denying the defendant's motion to suppress. The 2 issues before the court today both involve the search warrant and affidavit relied upon by the police. The first issue, as discussed presently, is whether there's sufficient information to, 1, establish the veracity of the confidential informant, and 2, the sufficient nexus between the location of the search warrant, that being 42 Lion Street, apartment 2L, and the defendant. Beginning with that second issue, it's worth pointing to Commonwealth v. Escalera and noting that there's no bright line rule that establishes the nexus between the defendant and the location of drug dealing, but instead there's a substantial basis for concluding that the evidence connected to the crime will be specified on the premises. When we look to...
If I were the judicial official whose job it was to decide whether there was probable cause, wouldn't I want to know that this defendant had connections to 2 different units in this building?
It certainly could be helpful, but again, there's the information present in the affidavit as is to connect the defendant with apartment 2L specifically. When you look to paragraph 12, there is the reference directly to the previous search warrant. It just does not include that additional information, as you noted, that it is to...
Isn't that pretty important information that, again, putting your self in the mind of the person who's got to decide if there's probable cause, saying, well, how do we know it's apartment 2 and not apartment 1?
I think there's two considerations there. The first being, of course, it could be helpful, but because we're looking to, again, establish probable cause with this search warrant and affidavit, the information is sufficient based on that idea of, again, dealing with probabilities, excuse me, and reasonable inferences.
If it is sufficiently established that the controlled buys were, in fact, in 2L.
Yes, Your Honor. And if we wanted to establish that, we'd look to cases like Commonwealth v. Desper, Commonwealth v. Warrant, or Commonwealth v. Ponte. You mentioned earlier the idea of not actually, the police not observing the confidential informant go directly inside of apartment 2L. Desper, Warrant, and Ponte all speak to that idea. There's a distinguishment between our case and those cases because in our case, the confidential informant's veracity was previously established through their known identity to the police, they're a carded BPD informant, and then they've also participated in arrest and provide information that's led to the seizure of narcotics in the past. In Desper, Warren, and Ponte, the confidential informants involved had no established veracity. It might have been their first time in those cases. And then again, distinguishing amongst those cases, Desper and Warren both involved 3-story or 4-story level units. 4-story level.
The reference to carded, does that add anything when we don't know any facts behind that? Can the police just declare someone's carded and that adds something?
It's helpful in the sense that if we look to Commonwealth v. Whitfield, that would be 492 Mass 61, was not cited in our brief. We can look to the idea of Rule 3.3 of the BPD Rules and Procedures. It establishes what a carded informant actually is. So it kind of eliminates the actual discretion. So the affidavit is not simply saying or using a term of art to say that they're carded, but it matches.
That information described in the affidavit, what it means to be carded?
It is not, Your Honor.
So how is the judicial officer supposed to know that?
I would base it, again, on the idea of probabilities and reasonable inferences.
Sometimes you have no offense taken to a housing court judge as reading a search warrant, has no idea about anything about what carded means. So how is the judicial officer supposed to know anything about what BPD carded means if it's not in the affidavit?
They may not know, as you mentioned, that particular justice. They would have to, again, consider the totality of the rest of the information in the affidavit. That would look to the idea that the affidavit establishes that the identity is still known and contactable by the police and the affidavit themselves. And then looking to, again, the additional information after that, the collaboration between that confidential informant in the past with police that has yielded narcotics, and then finally with the 2 controlled buys that the confidential informant participated in. Again, considering that as a whole, that would help to supplement possibly that lack of understanding with the term carded.
Can you help me with something in the record that is confusing me? On page, I think it's 58 of the record, there's the return of the warrant that lists 13 things that were recovered. And then, though, on page 60, there's another return of a warrant that says no items recovered. Can you help me? It looks like it refers to the same date and time for the search. Can you help me why I have to?
Your Honor, I believe that is the difference between the search warrant for the location itself and then for the person.
Okay, so is the second one is just for the person?
I believe, Your Honor.
Okay. Thank you.
Can I ask you a question on the prejudice issue? You say that the test is, to excise any improper information, or in this case, to add back in what should have been there regarding apartment 1L. Hasn't the SJC reserved the right back in the 1980s to say that that may not be the complete test, because they said that we reserve the right not to follow the federal rule, excise rule, And if the facts are bad enough about what the police did, that might be enough, even if no prejudice can be shown.
Your Honor, I'm unfamiliar with the case that you're referring to from the SJC. I would said, as you mentioned, determining how, say, bad the omission possibly is, I would compare this case to the case in Ramos, where in that case there was such a material misrepresentation as to, in that case, it was a canine and how much that canine had participated in previous fines for narcotics. In that case, I believe the affidavit stated it was 150 fines, and in actuality it was only 5 to 6. So that's clearly quite a material misrepresentation. We could look to the case of Commonwealth v. I believe it's $992, where the court there said that minor omissions or misrepresentations do not invalidate.
Why was this minor? Again, putting yourself in the mind of the judicial official who's asked to issue the search warrant, why couldn't one view this application as intentionally misleading? Because it talks about the address, and the address, and the address, even mentions a prior search warrant at the address, and fails to mention that it wasn't this apartment.
First, Your Honor, I would point to again and emphasize that when we're reviewing the search warrant affidavits, we're not looking to parse the information or parse the language present, and we're not trying to apply a hyper-technical sense. When we start at the investigation, we notice the investigation part of the affidavit, we notice the language changes. It starts with at or around 42 Lion Street, and then it switches to around, I believe it's paragraph 9 and then paragraph 11, 42 Lion Street, apartment 2L, showing again that that sufficient nexus is established directly by the two controlled buys that the confidential informant is participating in. The Commonwealth maintains that the applicant is not trying to omit or try to obfuscate that reference to the search warrant. It includes the direct reference number to that past search warrant. And again, it's not looking to hide that information or try to confuse.
How do we know that? Why not have an evidentiary hearing to establish whether or not the defendant has shown his entitlement to a Franks?
It would again be looking to that idea that really the defendant generally needs to show a substantial amount or a substantial burden that comes from Commonwealth v. Andrew or Commonwealth v. Armal. That's substantial showing prior to the case. Again, here, even if we were to insert that idea that it is apartment 1L was where the previous search was, it would really distinguish that the Commonwealth or the applicant was not relying on previous, possibly stale information as that search warrant occurred over 18 months ago, but again, directly with those two controlled buys that the confidential informant participated in.
What information is contained in the affidavit other than the affiant's perhaps conclusory statement that apartment 2 was the residence of the defendant?
Your Honor, I don't believe that there's additional information that does look to establish that it is in fact his residence.
So doesn't that cut against the affiant's in paragraph, I think there's a few paragraphs where he actually talks about drug deals are often done out of somebody's residence?
That's correct, Your Honor. Again, the Commonwealth would point to really just the investigation starting again at that 42 Lion Street in or around and moving to apartment 42, apartment 2L specifically, establishing the nexus there. The residence, again, looking back to Escalera, there's no bright line rule that establishes that residence is required or there's additional information that's required when it is a residence.
So is it your position that 2 controlled buys out of 2L is enough of a nexus to get a search warrant for 2L? Those facts alone?
It's also supplemented again by the fact that the confidential informant has an established veracity or has prior collaboration with the police. That does look to strengthen it. Again, the Commonwealth v. Desper and Commonwealth v. Warren, that confidential informant was still allowed to be relied upon.
I conceding for purposes of my question the reliability. If that goes away, forget about the whole thing. We're talking about nexus. That is where defense counsel is sort of focusing at least her argument today. So is the 2 controlled buys in 2L enough of a nexus to say we can search that apartment?
Yes, Your Honor. The 2 controlled buys are enough to establish the probable cause. If there are no additional questions, Your Honor, Commonwealth will rest on their brief.
Check. I don't see any. Mr. Wolf, is today your first day arguing in front of this court?
Yes, Your Honor.
Well, welcome, and I hope it's the first day of many more. You did a good job.
Thank you.
Excellent job.
Thank you, Your Honor.
Our next case is 2022 P0991, Commonwealth versus Peter Akara. I hope I pronounced that correctly. Attorney Cox, we are ready whenever you are, but take your time. Don't feel rushed.
Good morning. May it please the Court, Jennifer Cox appearing on behalf of Peter Akara. Mr. Akara appeals from a conviction of trafficking in cocaine after a bench trial in Suffolk Superior Court. As the panel is aware from the record, his conviction stems from the Boston Police Department's discovery of cocaine in his home, and the numerous appellate issues that we've raised all deal with motions that pretrial and trial motions that were denied that all sort of relate to the Commonwealth's charging decision with charging him only with the cocaine in the home and not with the 3 controlled buys that precipitated it. And as I said, there are 7 issues raised in the brief, and in the interest of time today, I would focus the oral argument on the discovery motion, the motion to disclose the Commonwealth's, the confidential informant's identity, and the Franks Amaral motion. Certainly willing to be redirected by the court if you have interest in the other issues.
Well, the issues all overlap.
Yes, yes, and so they're presented in chronological order in the brief because that sort of shows the flow of with the denial of motion 1 and 2, then he couldn't meet his burden on 3 and so forth.
You would agree that the charging decision is relevant?
Yes.
Okay.
Yes, and as from listening to the SJC's oral arguments in the recent Whitfield and Gandia cases, as Justice Gaziano put it, the Commonwealth would be stupid to charge otherwise on these facts. So certainly I know there are a lot of cases before Your Honors that arise from these exact fact patterns.
Right, in order to preserve the confidentiality of confidential informants.
Right, for the informant's privilege.
The Commonwealth essentially has to not charge certain crimes, even if they believe those crimes had occurred.
Yes.
Because of in order to favor confidentiality over the prosecution.
Right.
So, so with that background and acknowledging that the judge could consider that, in other words, that once they've made that decision, it does put some sort of parameters on the analysis of the issues that were raised.
Correct, yes. And certainly in this case, it illustrates that even if, when each decision is considered on its own, which I, recognize is a large part of this court's job, by the time Mr. Akara gets to trial, he is left with nothing to say. So this is a case where I think the constraints that are put on the court by these decisions that stem from the protecting the informant's privilege shows here that, to the extent he has constitutional rights to due process to present his defense, they really were significantly, or if not totally, abrogated
in
here.
some cases, one does not have a defense.
Right. But
and this is a case where he was found, crack cocaine was found in the apartment, and along with $59,000 worth of cash.
Right.
Highly suspicious evidence.
Yes, and what I would say to that point, Your Honor, is this case is different in that Mr. Akara's defense the whole time has been that he never possessed the drugs that were found in his house, that they were planted there by police. So certainly, we can, have opinions on whether that's accurate or not, but that has been.
And defense counsel got to cross-examine the people who found the drugs and asked them whether they planted, and they said no, and the jury got to evaluate.
Right. Well, he was pro se by the time of trial, and it was a bench trial, which I know are not facts in my favor, but just to clarify for the record. So he did ask the one officer, did you or other officers plant drugs in my house? And he said no. But yes, so that was the extent of his defense. Essentially, was that one question to the one officer. That's correct.
And that was his defense, right?
Yes.
And he had...
It's not that they weren't his drugs.
He
it's
didn't
that
have
the
any
drugs were
affirmative...
brought in.
He didn't have any affirmative evidence to that effect.
Correct. Yes, he did not.
So to the extent that we were going to be looking at some sort of prejudice analysis with respect to the various arguments you've raised, we would have to, I guess, look at whether, if any of those motions had been allowed, they would have strengthened his defense that the drugs were planted.
Right, and that's his argument, that they were material to that.
Explain to me how those two concepts are actually logically connected.
Yes, so if his defense at trial, as it was that the police planted the drugs in the home to be able to get the $59,000 and seize that, if he was able to show basically any deficiency in that the confidential informant didn't exist, was not reliable, the controlled buys never occurred, any one of those things, the argument is that would be material at trial because he could show if the police were deficient in their, or dishonest, in their performance of their duties in the case, that would strengthen or corroborate his trial defense that they also planted the drugs there. Basically, if they fabricated these things.
Is the theory that they planted everything, the drugs and the money?
No, the money was his, and his theory is
that
drugs were to get the
the
money.
police somehow knew that there was that money in the house.
Yes, and that's not on the reasons for that are not on the record.
And in order to get that money, they planted drugs.
That was his argument, yes. Mm-hmm.
How would promises, rewards, or inducements of Randall helped any of those?
Sure. So the promises, rewards, and inducements would go to, obviously we have cases that show that is very material to the confidential informant's reliability and credibility and, motive to fabricate. So here, it's sort of twofold. The argument is that. And then secondly, also a disclosure of promises, rewards, and inducements might also have led the Commonwealth to, in finding that information for discovery, to show perhaps the confidential informant did not exist, as said. So that is twofold, the sort of run-of-the-mill reason for wanting that information, and second, that also would have perhaps...
Saying that perhaps the CI did not exist, I understand many people feel that way, but don't you need something to get your hooks into in terms of showing that this, in one of the facts you relied on to try to, I think in your words, make the judge skeptical of this was the absence of GPS data.
Correct, yes. Mm-hmm.
Why is that material where, yes, the Commonwealth might have been able to cross-reference the GPS data and the specific location of these controlled buys, but A, they didn't have to do that, and B, if they're worried about revealing the identity of this informant, they presumably wouldn't do that. So why is that a big deal?
So the GPS, as Your Honor said, as the search warrant affidavit acknowledged, Mr. Akara was on a court-ordered GPS for the whole time here, including when the controlled buys allegedly occurred. They acknowledged that he was on that. They acknowledged that at the time of his arrest, he was wearing it as well. So the reason that the GPS is, and I have to concede part of your point that the government had no obligation to affirmatively do that, but the attorney at that time of the discovery motion cited that in her as an omission from the search warrant affidavit, that this is something that, as the judge in her words said, caused her, one factor caused her to have some skepticism of the veracity in the search warrant affidavit. And again, like where the defendant's position the whole time has been the controlled buys never occurred, the CI probably does not exist either because of that. The GPS is something that defense could have used to show, and again, as I go on about at length in the brief, the the defense attorney at that time offered to please redact the information about the CI. You can do it pursuant to a protective order, but it would have allowed his defense counsel to check his GPS coordinates to see, did he ever go to the locations of the controlled buys during, the 6-week or whatever period that preceded the search warrant affidavit. So that was another sort of, in trying to go along with the court's decision to not to deny the motion to disclose the confidential informant's identity. This is something that would not have breached the privilege, would not have pierced the privilege, but would have allowed defense counsel to do her job, to investigate the case, to be able to try to make a Franks, support the Franks motion. And as the SJC and this court have said in relation to the Franks-Amaral calculus, in cases...
I hear what you're saying, but I also am trying to figure out why the Commonwealth's characterization of this as a fishing expedition is inaccurate. Yes, if you looked at all this information and really dug into it, you might be able to get your hands on something that could be turned into a Franks issue, but don't you need something to begin with?
Yes, and I understand your Honor's question now, and I think the difference here between this case and the other cases that in the same similar posture is here, a lot of the times in the cases the defendant's argument is just the controlled buys never occurred. And then the issue of the drugs in the home or the car or whatever is a separate thing. Here he's also saying those drugs were planted there. It's not that, oh, oops, you got into my house now, you found my drugs. Here he's saying that also was part of an ongoing scheme by police.
Right, but other than, how does this get beyond the level of speculation?
And again, in some of the cases cited in the briefs, the court points to the defendant either, example in the recent Whitfield case, which is one of the 2023 cases, the court noted that the defendant didn't say, merely pointed to that there was a possibility that the confidential informant didn't exist based on their lack of a proven track record as delineated in the search warrant affidavit. And here we are saying that the confidential informant didn't exist.
I know, but
have that in
beyond just a naked assertion,
right.
What is there to support that?
And I mean, I understand that.
I don't want to be, too blunt,
right?
But
I understand what you're
a person can say anything.
Right.
This person doesn't exist. That person doesn't exist. This person exists. But
absolutely,
what's the basis for saying that?
I think the basis here is that we have a Akara's signed affidavit, so it is a statement under oath. So it's different than just counsel saying.
And does he have personal knowledge, one way or the other,
personal
of
knowledge
whether
that he said,
does he have personal knowledge as to whether the confidential informant exists or does not exist? No.
No.
But okay, so there is no percipient witness who can say whether or not, who can say that the confidential informant doesn't exist or that these controlled buys did not occur. We have only a percipient witness who says they did.
Well, I would say that Mr. Akara is a percipient witness to whether the controlled buys occurred. Certainly he's not to the confidential informant's existence generally, but we do have his affidavit saying specifically, I never sold drugs during, in Boston during this time frame here. So, and as the SJC noted, and this court has noted as well, sometimes that's all that the defendant is able to do, where they, claim the privilege, which as they did here, and then that ties into the discovery motion, where not only did they decline, to disclose the informant's identity, they also declined any other evidence, to provide any other evidence. And here, where the court said, this has given me reason to be skeptical, Commonwealth, if you got to choose, one of the laundry list of requested items that would best protect your interests and also allow the defense to investigate his case, what would you choose? And the Commonwealth's reply was, nothing. We don't, the case law says we don't have to give anything, so we're not going to. And again, I'm making arguments that within the existing case law, but I think my bigger argument is, in this case, this really shows he really did not, his constitutional right to present his defense was abrogated through each motion denial. So, I don't have a better answer to your question as far as, yes, he didn't have any other information.
His position would have been better if all they found in the house were the things he said were planted.
That if just the drugs and no money, certainly, yes. But
Right? Because that quantity of drugs supports an inference that they were the proceeds of illegal conduct.
Yes, which is why I'm not making a sufficiency argument here before you today.
Right.
Yes.
So, I mean, that's, yeah.
Yes.
Are there any other questions?
Yes.
Your client had a GPS on.
Correct. Yes.
Obviously, he doesn't have to do anything to present a defense, but at a motion stage, he does have an obligation to put in enough information to show why the evidence is relevant that he's seeking.
Yes. Correct.
If he had a GPS on, isn't it incumbent upon him in a motion for discovery to say, I have this GPS on, I want discovery about my GPS, so I can put in my motion for discovery that I wasn't at the locations where these controlled buys took place?
Yes, but the problem with that is that he didn't have any information about the location of the controlled buys, so just his own GPS data doesn't show anything, because he can't argue, well, based on my GPS data, I wasn't in this neighborhood, I wasn't here. They don't even, they didn't give a precise location, but they also didn't even give a neighborhood where the controlled buys. So I agree with your point, but I think on these specific facts, even if he requested from probation his own GPS data, he would have, there's no materiality to it in a vacuum of just his data. Yeah. And I see I'm out of time, so I'm happy to rely on my brief. Thank you.
Thank you. Thank you for your able argument. Attorney Knight?
Good morning. May it please the Court, Aaron Knight on behalf of the Commonwealth, asking this Court to affirm the defendant's conviction. Please bear with me. It's that time of year. I would first start off with the fact that the defendant had nothing to say because at every juncture because he provided nothing. The defendant.
But part of the argument is the search warrant affidavit was vague, or vague is perhaps the wrong term, but it was intentionally withholding information in terms of specific dates, specific locations and such. So it was kind of this bare minimum approach. So I hear counsel saying, yeah, I had nothing because they didn't give me anything, and it can't be that I have no ability to try to investigate whether, in fact, the CI existed and the controlled buys ever happened.
Sure, and I do understand that point, but I think the actuality of the situation is the only thing he did was give a blanket naked denial that he didn't do it. He didn't say I wasn't there. He didn't say, as seen in Ennis,
Well, how can he say
that he had an
there when
alibi?
he doesn't know where the there is?
Okay, but he also could have been like, okay, this was within 72 hours of the issuance of the search warrant. He has the search warrant, so he knows when that was issued. He could say within 72 hours of this issuance, okay, I work a 9 to 5. So I would have been at this place from 9 to 5. Or I was in New York City. Or anything. He gave nothing. He gave a blanket denial, which this Commonwealth has said is not enough. He could have given an alibi. He could have given a third-party culprit, as seen in Bonnet. He could have given a mistaken identity defense, as seen in Halsey.
How could he do third-party culprit?
He could have said, Your Honors, it couldn't have been me. I wasn't there. I was somewhere else.
Where's the there?
Okay, so if that's the situation that
perhaps he was in California, but that's...
I understand what Your Honor is saying, but the affidavit sets out that this person was selling drugs in the areas of Roslindale and I believe it was either Roxbury or Dorchester or West Roxbury, one of those areas. So point to facts that you weren't in those areas. Or
any day.
Anything. Anywhere.
But he doesn't know any day. That's like saying, I'm not
But he does.
I live in Boston. I wasn't in the city of Boston then.
I appreciate that, Your Honor. However, the affidavit does give, within several weeks of issuance for controlled by one, Controlled by 2, within 1 week or so of issuance. Controlled by 3, within 72
Doesn't the
hours of
defendant
issuance.
in his affidavit say, I didn't sell drugs during that time frame?
Actually, his affidavit is non-existent for the first 2 motions. The identity motion and the promises, rewards, and inducements are only an affidavit of his attorney. He does not put in his own affidavit that says anything for the first 2. So right there, his claim fails. For the secondary motions that he brings for Franks, he does say, I didn't do it. But again, he doesn't give any information as to why this information would be relevant to him. He doesn't say, my GPS points will show that I wasn't, or that I was in a certain place because within 72 hours of this date, I remember being here or here. That might have been something that was helpful, but the judge had nothing to conduct that second prong assessment. He had nothing to assess that second prong assessment of whether or not this defendant was entitled to any of this information.
Well, let me ask you a little bit about what he specifically requested in the CI privilege.
Sure.
The CI privilege is there to protect confidential informants from jeopardizing their safety.
Absolutely.
How would producing promises, rewards, or inducements to that person compromise either of those objectives?
First and foremost, Your Honor, I would just state that promises, rewards, and inducements is handed over for witnesses, percipient witnesses that are testifying at trial. And his first 2 motions, in fact, by Judge Tochka were allowed if that witness was allowed to.
What about if the person is potentially a witness at a motion to suppress?
There would be no reason for him to be a witness at this motion to suppress because it's a 4 corners affidavit.
No, what I'm focusing on is you said at trial. It could also potentially be a witness at a motion to suppress.
It could, but again, this informant would not have been a witness at this motion to suppress because it's a 4 corners affidavit.
So promises, rewards, and inducements to a CI has no relevance to anything regarding him?
It may, but here, again, he didn't give us any reason to have any relevance. He did not aver anything in his first 2 motions, the identity and the promises, rewards, and inducements. He had no one aver with firsthand knowledge anything about this situation. He did not provide an affidavit. His affidavit was of his attorney.
That's not why Judge Tochka denied the motion.
No, he denied the motion because he allowed the motion if the informant was to testify at trial. So technically, he did not deny the motion. The informant was not going to testify at trial because at the time the charges were simply of those found in his residence. And so he did not get that information of promises, rewards, and inducements because it wasn't relevant because he did not show at that juncture that it was relevant. He did not show at the next juncture when he continued to ask for the controlled by information or anything to do with the identity of the informant. He kept up the same claim this entire time, but gave nothing. He knew that this was not being approached, that this was not being granted, and yet still gave nothing further.
Counsel, are you familiar with the Hendren case?
I am, Your
handled
Honor.
By your office?
And I think you're smiling because you might remember me being in the back of the courtroom for that case. Yes, Your Honor, I am. That came out in October.
That was a case where there was a little more specifics given.
Absolutely. About
the control buys, and that allowed the defendant to make his Frank's argument.
So the difference is, if you'll allow me, the difference is in that case, Hendren put forth information that from jump that at the first 2 controlled by alleged dates, his car was in the shop. So what he was seeking was that 3rd or 4th, I think, controlled by
I'm very familiar with the fact.
Yes, I know you are. He was seeking that information to bolster his claim. So he had put forth evidence that during that time frame, which I still believe that there is a time frame given here that he could use. During that time frame, his car that was noted in the affidavit as having been used in these controlled buys was in the shop. So it would have been an impossibility, a factual impossibility. Here, we have nothing. He doesn't put any sort of impossibility on the record. He doesn't give any information whatsoever. And I would argue that in Hendren, knowing the information they knew, that next controlled by information may have led to the identity. But here, just giving anything over that the defendant has asked for on this showing would vitiate the entire purpose of that privilege. And
Except it has nothing to do with protection of the CI. That's why I started my original question with the purpose of the CI privilege. you seem to be asserting that no information at all about a CI should ever be given because of that privilege. So again, I go back to, do you agree that giving promises, rewards, or inducements about a CI does not necessarily go against the purpose of that privilege?
Of releasing the or of exploring the identity, I do not disagree with that. I do believe in some instances that could be a reason to do so. But here, the judge ruled the way they did because at trial that information was not going to be pertinent to the materiality of his defense at trial, because looking at this case specific, the trial charges were the drugs that were found in his home.
A related point, in this case, the same motion kept getting refiled in different forms. By the end, counsel got very strategic and said, here are 17 things you could provide that have nothing to do with revealing the informant that would give my client and the court system as a whole some confidence that the CI and the control buys actually happened. Just to give you one example, I think it was the serial number of the field test of the drugs after the control buy.
Sure, Your Honor, I understand.
And why is that an unreasonable ask?
It's an unreasonable ask because, again, he gave no reasoning as to why this affidavit should even be called into question. He gave nothing. He literally, at the first two instances, gave nothing. At the last few motions, all he said was, I didn't do it. If the level of assessment the judge had to go through to give over any of this information was, I didn't do it, everyone who said I'm not guilty at arraignment would be entitled. And then the purpose of this entire process is because we want these people to come to the police and to help the police so we can go after.
Sure, but it doesn't mean that you can withhold information that doesn't bear on the purpose of protecting confidential information.
I understand, but at the same time, he also didn't explain how the serial numbers of the lab tests would have been relevant at all. He just asked for them.
I mean, isn't it self-evident why they're relevant? It shows that there's some evidence that a control buy actually happened.
I think that, again, turns back to the fact that he wasn't charged with those charges. And it's not a vacuum. It isn't. It's a
What
process.
if the defendant had put in evidence of other instances outside of this case where Boston police officers may have lied in a search warrant? I can think of one or two.
Sure. So I think it's in two parts, right? Generally, maybe not. Specifically, if he pointed to any of the officers here or the particular affiant, maybe. Yeah. Why not? Let's go there.
Let me run a hypothetical by you.
Sure.
Let's assume that after each of the three controlled buys, the substances were field tested and they all tested as baking soda.
Sure.
Okay, no drugs. Nonetheless, the police went, put in an affidavit saying there were three controlled buys for suspected drugs. They get a warrant, they go, and everything else happens the way it did here. It seems to me that a defendant would be entitled to those field tests because they bear on whether or not there was probable cause to issue the warrant to search the house. You don't get to go search a house for baking soda.
Well, perhaps.
Right? And I can't see how the lab tests would have borne or compromised the confidential informant.
Sure.
So let's go back to the question Judge Milkey asked. Why is it that those, right, because it's not just he was charged with only what was found in the house, because this would bear on that charge. This would bear on whether the police were entitled to be in the house to obtain the evidence that underlay the charge they decided
At the motion juncture, not at the trial juncture.
Sure, but this is where we're talking about. So why is that not, why is the defendant not entitled to that?
He is not entitled to that because of the standards that we have and the showing that he made. He did not
But
make
what's
a
the
substantial
standard?
preliminary
What's
showing.
the standard? Because it wouldn't compromise the confidential informant's identity. It does bear on probable cause. If he asks for something that would bear on whether there was probable cause to issue this warrant, why doesn't he get that in discovery?
Because what he proffered to the judges, multiple judges, was not sufficient to assess the materiality and relevancy of the disclosure.
Well, he's asking for exculpatory information on his theory.
On his theory of which
yes.
he has provided no support.
Well, why isn't his affidavit to the, I think it's the last motion, and it's on page 91 of the record, why isn't that sufficient? Maybe I'll agree with you, for purposes of this, that the first few motions did not have proper affidavits, but on page 91 of the record, he gives specific time frames that says from August through September.
I'm sorry. He says,
that
during the
make it
time period of
relevant?
August through September 19, 2018, I was compliant with my GPS monitoring, but he doesn't
I
say
did
why
not
that's
sell
relevant.
or otherwise.
I did not sell or other, sure, in the Boston area during August, but that's a blanket, naked, I did not do this.
Well,
And that
what
is,
can he, again, I guess I go back to Judge Milkey's question. He doesn't have any information about specifically where the buys are. He doesn't know when, but he kind of surmises, and you kind of said you can use a few weeks here and there. August through September, I wasn't in selling cocaine in Boston. Yeah, it's a naked assertion, but that might cover when the controlled buys were. We don't know.
it could, but also mere denials are not sufficient. That's under Commonwealth versus Ramirez, 416, Mass 41, and I think this is a mere denial. Here, if I may finish, here he's saying I was on GPS and I didn't sell cocaine in Boston. But those two things taken even together do not prove that he was not in the area of Roslindale, do not prove that he was not doing other things in the area. He just gives nothing for the judge to assess that he was not, something else should be, he did not give anything else that should be assessed in terms of what he could have been doing otherwise and why this is not true. He has not met this burden. Do you have any more questions? If there are no further questions?
No.
I'll rest my brief. Thank you.
Thank you. Thank you both, and the case is submitted. For those of you who are planning ahead, we are going to take a mid-morning break after the next case. Mid-morning break will be about 15 minutes. And the next case is 2023P0318, Commonwealth versus Alfredo Ramirez.
Thank you. May it please the Court, Attorney Kristen Friedel on behalf of Mr. Ramirez. Your Honors, this case is about a motion for new trial that was an abuse of discretion that it was not granted, where Mr. Ramirez was not given advice pursuant to Padilla, pursuant to Severian. I would suggest that the duty was clear. I know the Commonwealth's brief does touch upon, I believe, a good portion of it touches upon whether or not there was a duty to advise Mr. Ramirez, so I'll start there. I would suggest that Levernenko does state that this is the loss of a potential discretionary relief is a clear and serious benefit. In Mr. Ramirez's case, although he was, he entered without inspection, and that in and of itself made him removable, what happened, and I think Gordon touches upon this, and I think actually Nunez-Diaz, which is not a Commonwealth case, but the Commonwealth did cite it, I think in footnote 6, for precedential value, for persuasive value, that is actually favorable to this point that although it did not make him removable by nature of the charge, it made it nearly certain that he would be removed. Because although he was charged with a crime involving moral turpitude, which in and of itself does not make him removable, it made the fact that he was subject to removal, it elevated that to a situation where he was completely barred from any relief, and it made it certain that he would be removed once the government acted on that notice to appear.
So this seems to me like, I don't know if this is the right word, like a second-tier consequence of the plea, right? A first-tier consequence would be you plead guilty, it will cause you to be removed or deported. A second tier might be, well, this plea isn't going to cause that, but if there's another reason that's going to cause you to be deported, then this plea will bear on that decision. In this case, it will foreclose a discretionary decision in your favor.
So I'm not sure I would categorize it as secondary because I think the gravity of what the plea did wasn't essentially, again, he was subject to removal, but it made it inevitable that he would be removed.
Can I just, specific clarifying point, am I wrong to think that had he had a green card, this was a deportable consequence of the plea? It's just what adds some gray is that he didn't have a green card and therefore he could have been deported anyway.
So I don't want to misspeak because I'm not sure if he was a legal permanent resident, if this would be a removable charge. I know that it was
a crime of moral turpitude, correct?
Correct, but I do believe, as the Commonwealth said, that it would need to be 2 within 5 years. So this charge, I don't believe it was removable. And I don't want to misspeak because I'm not certain.
Right, if he had been here lawfully on a visa of some sort or a green card, whatever, so if he was here lawfully, this plea would not have itself resulted in his being removed.
That, I believe so. And again, I didn't brief the issue on, it's a different statute or different section of the statute for LPR or legal permanent resident cancellation. But I don't think that that should make much of a difference. And here's why. Well, first, because I think there are individuals who are here as LPR or who have green cards may have at one point started out as having an illegal or unlawful presence, and it was that they were able to cancel their removal. So I don't think that should be held against them in that regard. And secondarily, I don't think that just because someone is already removable, that they are not entitled to the same advice regarding their deportation consequences. It might make it more important that they receive this advice.
Well, plea counsel's advice, at least as far as it went, was correct, wasn't it?
It was partially correct.
So it wasn't that it was wrong because this is a crime of moral turpitude. He would get excluded. Plea counsel looked at that and said, if below a year, you will not get deported. That was correct. It was the second part, as Judge Willahogian was pointing out, that is the thrust of your argument.
Exactly, yes. So yes, the charge of itself, if he had more than a year, then it would have been an aggravated felony. So he was correct, and I think that bolsters, again, the argument about why this was prejudicial to Mr. Ramirez, because the plea, from plea counsel's notes, appears to be constructed in order to preserve his immigration consequences. And so for someone who then 20 years later finds out, when I received this legal advice that I told, and then you can see in the notes where it says, if causes deportation, try the case, essentially. 20 years down the line, he's now in removal proceedings. He believes that that plea was not going to affect his deportation, and in fact, it absolutely foreclosed his relief.
Well, it didn't cause his deportation. I mean, we can get into some very fine words there. Was there anything at the time that this plea was entered, do we have any case from that time, so it's in 2005, saying that an ordinary fallible lawyer was obligated to provide the advice that you say was not given here?
So I don't know of anything. I think.
Okay, so we would have to be saying basically that.
I believe so, and I think it's under the Article 12. I think the court did say that in Levenenko, and it is slightly a different analysis, but I think this case is actually stronger because in Levenenko they said it was a clear consequence when there was a loss of discretion. Well, a potential loss of discretionary relief because the standard that Levenenko would have to prove was higher. So there was still a potential, that it's just the standard was increased. But
the
here,
problem is, with the analogy to Levenenko, is the defense plea counsel didn't even know what the defendant's citizenship status was. He never asked. He did nothing because he didn't know that he was a non-citizen. Here, the lawyer knew, did some type of research, and his research, at least as far as the initial crime part of it, was correct.
so it was, I would say it was partially correct, certainly that on the aggravated felony portion, but it was, I don't know if it was incorrect or he just didn't.
You're arguing it didn't go far enough.
Right. And in Levenenko, although that attorney didn't even discover that the client was a refugee, I don't think that then correlates to say that because this attorney did try to be diligent in representing the immigration consequences, that it went far enough to protect Mr. Ramirez's constitutionally protected right to, under the Sixth Amendment and Article 12.
I guess this is a broader question, maybe not for you, maybe for some other powers that be, but how far does plea counsel have to go?
So I'm glad you asked that because I did think about where the line could be drawn here, and I think there could be a succinct line drawn in this sort of analysis where when you're looking at, for instance, cancellation of removal, as I'm sure the Court's aware, has different elements that would have to be met, that 10 years continuous presence, good moral character, and on and on. So where there is something that is a complete bar, such as this, where so if you look at, I think it's 8 U.S.C. 1182, that's the inadmissibility portion. There is a section of that, in that section it lists what makes someone inadmissible, but the cancellation statute has pretermitted crime. So if there is something that is a crime involving moral turpitude where you are completely pretermitted from even applying, I think that is a clean line the court could draw where someone doesn't have to, an attorney doesn't have to research, well, will this affect the analysis of good moral character? If it is a complete bar, I think that is a clean line that could be drawn.
Can I ask about the remedy here? You're asking us to grant the motion for new trial. Isn't remand more appropriate because the judge in this case didn't really weigh anything regarding the Clark factors, your client? I know your client asserted based on the notes that he wanted to go to trial and the affidavit he would have gone to trial, but don't we need a decision by the trial court judge about that?
Well, so I think that if the facts are uncontroverted, which I believe at the hearing the Commonwealth relied on the arguments or made arguments relying on the plea counsel's notes themselves. If the facts are uncontroverted or if the argument is solely a legal argument, I think the court could remand and vacate. If the court found it was more appropriate to remand for a hearing, I think that's our secondary argument. There is a substantial issue raised because it's a constitutional issue, and I'd say he's made a substantial showing where here it's a unique case where luckily decades later he was able to have contemporaneous note-taking.
Isn't there a substantial part of Levenenko that talks about just because a defendant says he would have gone to trial, that doesn't end it because you have to look at whether that decision is reasonable or not?
Yes.
So how do we find, even with the record, that it was reasonable or not?
without a hearing?
Yes.
So I still think you can. So I think part of that is talking about in Larenko the special circumstances. Here, you don't have to look for special circumstances because I think you can see at the time what his desires were and that he placed a special emphasis on his immigration status. And turning towards whether or not it would be a rational argument, I think you can look to, I think it's Lee versus United States that was cited in the brief, where the potential sentence wasn't great. So it was 2.5 years was the maximum in district court. It wasn't state prison time. He was in the country for 9 years at this point in time. He was 1 year away from having the 10 years continuous presence. I think that bolsters the argument that a reasonable person, a rational person, would elect to.
Counsel, isn't your easier argument that jury could have come back on a lesser included of simple A and B?
Yes, that as well. He could have potentially, I think the sentence was 59 days in the House of Correction. He could have negotiated perhaps, or the jury could have come back for an assault and battery where an 11-month sentence would have protected him on both grounds, and he wouldn't face the dire consequences that he ultimately faced in 2018.
Can we look at all, and I know it was no prost before the plea ultimately happened, but can we look at the fact that one of the original charges was a serious felony?
So I don't believe so, and here's why. If the null pros was made at the same time, then I think perhaps at the same time of the plea, I think there could be a reasonable inference to be made, an argument to be made that that was some sort of benefit to him. However, as I think I put in my motion, the reasonable inference is that it was null pros because they didn't have jurisdiction in that court. It was merely, I believe, a month after the arraignment that it was null pros. I think, as an aside, that June of 2005, that's probably where the immigration court mixed up some dates when they were asking that in the trial court. I think that's maybe where that came in. But so no, I don't think that can be considered because it wasn't a benefit to him that he would have foregone if he went to trial. And so going further now just into the special circumstances, as I said, I think that a lot of the case law talks about special circumstances regarding how long they've been in the country, their ties to the country, but those are all circumstances to look into the mind of the defendant. And again, here we have a very unique situation where you have the contemporaneous notes of the plea counsel. I would request the court allow the remand for either the vacation of this plea or for an evidentiary hearing as he's made a substantial showing for a substantial issue. If there are no further questions, I can rest on my brief.
Okay, I don't see any. Thank you.
Thank you.
Attorney Nadeau.
Thank you, Your Honor. Good morning. May it please the Court. Stephen Nadeau on behalf of the Commonwealth. Before jumping into the meat of the issue, I'd like to begin with a consideration that I think should kind of color the assessment of all of the issues, and I think ultimately the Court, under de novo review, will reach the same conclusion the motion judge did here, which is that the defendant did not make a sufficient showing of a substantial issue. And that primary issue concerns questions about the defendant's credibility, extending even to his identity. That was the primary issue that the motion judge was alert to. I'm not entirely clear who is in front of me. Is this Alfredo Ramirez? Is it Sergio Medina? And that was not a question that existed only at the time of the motion. Counsel's notes indicate that in all of their discussions, Sergio Medina was the name he gave Attorney Fortier. That apparently was not his name. And we don't know what detail the defendant would have given about his precise immigration status. He may have said, yeah, I belong here, but I am still worried about deportation.
We've seen all those things in the record, but I guess and the evaluation of his credibility certainly could be made on the papers, but it doesn't have to be made on the papers, and probably more reliably can be made after an evidentiary hearing. On the central issue, which is because I don't see the question of aliases as bearing on how we would articulate what first prong Sufficient is in these circumstances, right? Perhaps you could just focus on that. That would be helpful to me, which
Sure.
is
Yes.
first prong Sufficient. What was counsel's obligation? And why doesn't it include, or just to play, devil's advocate, why was it not deficient here, where it was correct insofar as it went, but it wasn't, at least as alleged, didn't quite go far enough?
Well, under the circumstances, and this is kind of where credibility also becomes relevant, we don't know whether the advice went far enough because we don't know exactly what Attorney Fortier may have been told. If for instance, defense...
Right, and there's no affidavit.
Correct.
And he doesn't remember.
Correct.
Right. And but the judge, it doesn't look like the motion was denied because the judge decided that he did. I don't.
Right.
I don't
have the
see
benefit of any.
We don't have the benefit of anything to tell us that the judge made any findings regarding what this defendant was or was not told about the consequences of his plea.
Correct. Other than that this plea would not result in his deportation or would not trigger the deportation proceedings against him.
Would not cause, I think, was the word. But
And I think what
I may not
comes in the notes was it cannot result in deportation, and that in itself is a little ambiguous, whether it means kind of the end result of all proceedings, or is it just what triggers the deportation process?
Aren't the niceties of what label you put on it more or less irrelevant for the defendant? I mean, whether or not it's being deported for this or being prevented from staying for this, it doesn't matter.
I think from the defendant's perspective, I probably agree with you, Honor, but I think the analysis as it stands under Padilla and under our own Article 12 analysis has been that it is what makes you deportable. And it's sort of a split with many jurisdictions saying that Padilla and their own jurisdictional authorities do not extend to the collateral consequence of ineligibility for removal. And I think Iowa and North Carolina say that, that it does, although those are cases that came much later, after 2005. I think the Iowa case maybe is 2017, and that's the earlier one.
What about Lavrinko? How are you getting around Lavrinko? It says, the court said that the relevant immigration consequence is the substantial risk of losing a viable avenue for discretionary relief. How isn't that this case?
I think for the reason you mentioned during my sister's argument, just that there was no attempt to explore the issue.
So that's dicta?
In that case. Well, perhaps, because as a panel of this court in Solis says, it indicates it still seems to be an open question whether that is required under the law.
So do we have to close that open question for this case?
Arguably, yes, but for a variety of reasons, and for the fact that it is such a sort of less clear than are you merely looking at doesn't make you deportable, should not be said. And I recognize, as my sister cited, that Gordon refers to the ability to apply for cancellation removal is a serious benefit. And that's cited in Martinez, which I think is a 2012 case, which I think is the first time that that remedy is acknowledged as being a serious benefit. But as the concurrence and dissent in Padilla noted, there are many serious benefits that you may lose as a result of a criminal conviction: the right to vote, the right to public benefits, right to certain licenses, firearms, professional licenses, so on and so forth.
Doesn't that come back to whether or not this is considered a collateral consequence or a direct consequence?
I think so, and I think our position would be that once you're getting into that question of the relief from removal as opposed to removal itself, that would be collateral and outside of the scope of Padilla and our own holdings.
Whether it's collateral or not, and I know you don't want us to accept the defendant's affidavit or the notes of defense counsel, but let's, for sake of this discussion, we do. It's pretty clear, isn't it, that this defendant was saying, I'll plead as long as it has nothing to do with me getting kicked out of the country. If it does, I'm going to take the risk and go to trial.
And I think part of the difficulty is we don't know that it was as long as it has nothing to do with me getting kicked out of the country, and if for instance, plea counsel doesn't know that he is there, or he is in the country illegally and thereby already subject to removal, that may color the advice.
Don't the notes, at a minimum, establish that the immigration consequences were paramount in his
absolutely,
mind?
Yes, and certainly no reason to dispute the notes themselves as far as they go. Obviously, still lots of questions unanswered, and again, given that counsel has received what is apparently plainly incorrect information going down to the defendant's name in those discussions, I think should color, again, the overall evaluation of what counsel knew and what he was required to say. But after that conversation in July, and I think the change in circumstances is significant, that's a meeting they have. The defendant is out on his own liberty. He meets with his lawyer and says, this is kind of top of mind, my main concern. About a week and a half after that, he is arrested on an assault and battery against his girlfriend, who is apparently the star witness for this self-defense claim. He is then held without bail, because his bail was revoked on this ABDW case. And so at that point, the sort of balance of interests changes at the time of the plea. He's locked up. He's now facing multiple charges, and the benefits at this point are clear. I get out today, and I can walk out.
It certainly muddies the waters as to what happened. But again, and maybe if the judge down below had made credibility determinations, I would agree 100%, didn't believe him. We don't have that. So isn't remand what we need to do here? Because we don't even know. I mean, they make a pretty good showing, substantial showing, for an evidentiary hearing that a couple of the prongs have been met here. Number one, immigration was paramount concern. Number two, the remedy seems to be that he wouldn't have pled but for the erroneous advice. And now you throw into the equation, well, should we even believe that regarding the defendant? How do we, as the appellate court, make that decision as to what he would have done?
Well, I think, bearing in mind that the burden is on the defendant to make that initial substantial showing here, granted, wouldn't have the benefit of credibility findings, but the credibility issues are baked in to the filings themselves. They are apparent on the note.
Sure,
they are apparent by...
But we all know we can't make credibility assessments in the first instance here.
But given the doubts, rather than the credibility, the doubts inherent in the filings, it does not rise to the level, and the filing did not clarify really any of those doubts. I know there's filings purporting to show that they are the same person, but there's discrepancies in the birth dates and all these things, and I think that's part of...
What's the closest case on these facts? And when I'm talking about these facts, I'm talking about we have contemporaneous notes from counsel, because that seems to me really the crux of the issue here. If we didn't have contemporaneous notes of counsel, it would just be a far different case.
Right.
But we have contemporaneous notes, indicating, as Justice D'Angelo said, a clear idea that immigration consequences were important to the defendant, and enough so that it was going to play a role in whether or not to plead. The lawyer researched the questions. It doesn't look from here, it looks like he focused mostly on the length of the sentence. Do you have a case where we have contemporaneous notes of counsel, sort of like this, where we've said the motion didn't raise a substantial issue meriting an evidentiary hearing?
I can't think. That's
Me neither.
Factual.
Yeah.
But as far as a good case dealing with the specific issue of cancellation of removal, I think the unpublished decision that's part of our addendum and cited solace, deals with even if counsel's advice should have gone that far for a variety of reasons.
Right. It may be that it comes out exactly in the same place, but I'm not so sure. I have a hard time. I'd like to hear you on it just doesn't raise a substantial question meriting a hearing.
And which point exactly? I'm sorry.
Just on this record, what's your best argument that the motion was not, the defendant did not raise a sufficient question to merit an evidentiary hearing?
Again, because it is not established that counsel's advice was incorrect. The defendant has not established exactly, and again, this goes to the questions of identity, what was told to counsel. If he didn't know that he was already subject to removal, counsel would not have known to go farther than the mere removal consequences rather than the potential to apply for cancellation of removal.
I mean, isn't it, this part, we've seen this argument on this panel at least twice this month, and I'm totally puzzled by it when the Commonwealth makes it. So just something to think about. Isn't it sort of necessarily embedded that the defendant is deportable just by, for some reason, presumably lack of sufficient documentation to be here, if for any of these discussions to have been taking place? So I don't see that really as an independent consideration, So when you say, well, we don't even know that he would have been deportable, that seems to be a given here, right? I mean, a citizen wouldn't be having this discussion with plea counsel, with his plea counsel.
No,
so I don't understand this argument when the Commonwealth says, well, we don't know that.
And I think kind of what it goes to is presumably there is some subset of non-citizens who are removable because they check any of the boxes on that statute, but then, notwithstanding the fact that they are removable, they can apply for cancellation of removal. So for all counsel may have known, he's saying, well, you're not going to be subject to removal based on this conviction, so you won't get.
But we know, but I guess what I'm getting at, and I just don't have an articulate way of saying it, we know that his presence here is dependent on things, something, and the plea may affect it, right? That he, one way or the other.
Mm-hmm.
We'll leave it there. Sometime between now and the next one of these similar cases, I'll try to come up with a way of expressing the question.
I realize the time has expired, but I have to ask you about the separate argument about whether the plea was knowing or, if you will, intelligent. In your brief, you basically say, for all the reasons we've already just gone through, he loses that as well. What do you do with the Najjar case that is cited in your brief? Didn't that case, which was not a Padilla case, say essentially that if it was not knowing, a knowing plea, because the defendant was not informed about direct consequences of the plea, then it's structural error for which prejudice does not need to be shown. Putting these cases together, when you have a Padilla case, why doesn't that make all of Clark about how you show prejudice beside the point?
Well, because for a couple of reasons. First, because, and ordinarily it is our burden to show that there was a knowing involuntary plea, but given, the age of the case, how long it went on, after the pleas went unchallenged, the burden, I think, shifts. The defendant is held to kind of bear the consequences of his delay. So the fact that the Commonwealth can't provide the record of the plea to show what, colloquies were gone is no longer then held against us. And for the same reasons, he did not raise substantial.
Understood. But if these immigration consequences are deemed a direct consequence of the plea, why doesn't that make this not knowing by definition, in which case, at least under Najer, it's structural error and he doesn't need to show prejudice? I'm trying to sort this out.
Yeah.
This is not a trick question.
And I guess if we were not able to meet our burden, that would be the result. But again, given the length of delay, that calculus switches, and for the same reasons, he has not made a substantial showing on the first issue. He has not made the substantial showing on the knowing involuntary issue. And just to get to your question about the argument, what is the difference? The Tenth Circuit case that we cite in that long footnote, Don Juan, I believe, talks about lawful permanent residents and their concern about cancellation of removal. I don't want to waste too much time. I don't know if that gets directly to your question, but may provide some insight on that. There are no other questions.
Let me check. No. All right. Thank you both. Thank you both for your argument on the interest.